I thought we could start where we left off last session, or where you and Gabe left off last session, talking about the military commissions and your participation in a military commissions case. So, what was your first reaction when you heard that Guantanamo detainees were going to be tried by military commission?
I think my first reaction to that, and obviously that news really came very early on. So at
Really
that point,
early, right.
I was actually not even a lawyer yet. I was still a law student here at Columbia. And that was in November 2001, I believe,
Right.
that President Bush issued an order creating the military commissions. So it was a pure creation of the executive branch of government. Obviously, that version of the military commission is the one that the Supreme Court ended up striking down in the Hamdan case in 2007. Actually, 2000, was that 2007 or 2006?
I think 6.
Thereabouts.
Yeah.
And that's what led to the Military Commissions Act of 2006, so Hamdan must have been 2006, and in the Military Commissions Act you have sort of the legislative branch version of those military commissions. So my first exposure to the military commissions was in 2001 when I was still a student, and obviously at that point it wasn't really clear in November of 2001 who would end up being a defendant in those military commissions. It was sort of like the structure that was created, but who would be processed through the structure at that point was still unclear to me. I think everyone assumed that people who were captured in the course of hostilities in Afghanistan, perhaps the individuals who were suspected of being responsible for the attacks on 9/11, would be candidates for trial by military commission. It did strike me as odd that sort of an exceptional structure was created. In the same way, I guess, that I was having a hard time accepting the war paradigm.
What do you mean by that?
Well, I think the notion that the 9/11 attacks were an act of war, I think, was a notion that was very quickly put out there by, within political spheres. I think it was the immediate reaction of folks within the Department of Defense. Of course, they're conditioned to interpret events in that way because of their own training and professional background as military people. But I think very quickly, even within civilian spheres of our political leadership, that view was adopted. It was publicized through the media, and it was very quickly accepted by journalists, commentators, analysts, and the public. That notion was so quickly accepted was troubling to me, because I thought it deserved more reflection and debate, because it is really a significant shift. And I think had the attacks on 9/11 been treated as perhaps a particularly tragic and horrendously successful criminal action, then the course of history would have been very different. The fact that very early on they were just relatively unquestioningly accepted as an act of war, and that the war paradigm wasn't really questioned or interrogated significantly by the elected representation, be it on the Hill or by the intelligentsia and the academy and commentators and analysts and reporters. I think that set us on a path that we're still on today. So very early on, for the same reason that I had some doubts about the wisdom or propriety of the war framing for this particular historical event, as tragic as it was and as personally affected as I was by it as a New Yorker, I still questioned that, and I think the order announcing the creation of the military commissions and my reaction to it was sort of part of that same bundle. And I also wondered, even if we were to accept the war framing for what was happening at the time, I also wondered why we had to create a new military judicial structure when we already had the courts martial, in addition, of course, to our civilian Article III federal courts. So that was my initial reaction. I think my next really meaningful engagement with the military commissions comes years later, when I think it was in on August 8th, 2008, actually, was when I was retained by Ahmed al-Darbi, who was a prisoner at Guantanamo.
Can you talk about how that happened?
So he had, shortly before my first meeting with him on August 8th, 2008, he had been charged and referred for trial by military commission. At this point, we're talking about the legislative version, the post-Hamdan version of the military commission. So you could think of it as version 2.0 or 3.0, depending on how you want to look at the evolution over time. He had been appointed detailed military defense counsel, as consistent with the Military Commissions Act and the implementing rules that the Department of Defense issued. He wanted to retain civilian counsel to represent him before the military commissions. One of the men who was imprisoned in the same prison camp where he was held, which at the time was Camp 4, which is no longer in use. It's a facility that's a part of Camp Delta at Guantanamo, no longer in use today, as far as I know, at least at Guantanamo. But it was, Camp 4 was where so-called compliant prisoners were held back in 2008. So the prisoners were given, white jumpsuits, and they had privileges that the prisoners in camps 5 and 6 and the other prison camps at the time did not have. So Ahmed al-Darbi was held in that camp. One of his fellow prisoners there was a client of mine, an Algerian man by the name of Muammar Amir, who's now back home with his family in Algeria. And through Muammar, I received a request from Mr. al-Darbi, Ahmed al-Darbi, to represent him. So, I exchanged correspondence, like legal mail, with Mr. al-Darbi. And then on August 8th, 2008, I had my first meeting with him and began sort of solidifying the attorney-client relationship with him that still exists till today. So that was really my first meaningful engagement with the military commissions as a lawyer. Shortly after that meeting, I entered my appearance as his civilian defense lawyer before the commissions. Under the military commission rules and under the normal sort of courts martial rules as well, whenever there is a civilian lawyer on a case before a court martial or before a military commission, that civilian lawyer becomes lead counsel, even if there is a military lawyer. So, I collaborated with his military lawyer at the time. Since that time, he's had, about 6 different military lawyers, and I've been, the one civilian defense lawyer on the case for the duration. What happened with the case actually is interesting because it really, I think it really reflects a lot of what's wrong with the military commissions.
Okay.
And so he was charged, he was referred and charged, he was charged and referred in 2008. We started moving towards trial. We eventually reached the suppression phase. So one of the final pretrial phases in any criminal proceeding. And he had been charged with what was back then the normal sort of military commission cocktail of charges: material support, conspiracy,
right.
Both of which are not recognized offenses under the law of war. And that's one of the arguments we made. At this point in time, 2013, the DC Circuit Court of Appeals has agreed with us as to material support. They are more or less on the brink of agreeing with us as to conspiracy. I think even the Office of the Chief Prosecutor, as a legal matter, probably agrees with us as a legal matter that conspiracy is not a war crime that's recognized under international law. But I think as a matter of policy, that office is no longer interested in charging that particular crime because they're afraid of, how convictions of that crime could stand on appeal. But at the time, in 2008, Mr. al-Darbi was charged with material support, conspiracy. We were on our way to trial. We were at the suppression phase where we were basically making all kinds of arguments about what sorts of evidence the government should be able to rely upon and which sets of evidence were too prejudicial and whatnot. So just to give you an example, obviously we were arguing over the admissibility of some of his own statements that they were going to try to introduce against him, given the circumstances in which he had been interrogated in Bagram and Guantanamo, highly coercive circumstances. Mr. al-Darbi even signed a declaration describing the torture and abuse that he survived in Bagram and Guantanamo. That declaration is now public.
It's absolutely tragic.
Yeah, And his is one of the more extreme cases out of Bagram that we know about, at least. But obviously there are 2 prisoners that we know of who died, including Dilawar, whose death he more or less witnessed. So I think there was a lot of really powerful, moving details in his accounts of how certain statements were elicited from him. The other part of it obviously was also having to do with evidence that the government wanted to introduce about the 9/11 attacks. So a lot of what we were saying from the defense side was, this is prejudicial because even going by the government's own allegations, Mr. al-Darbi didn't have anything to do with the 9/11 attacks, and so why introduce that and taint the military commission members, like the military jurors' view of our client. So we won some, we lost some in front of Chief Judge Pull, who was our judge in the al-Darbi case, is the judge now in the 9/11 trial and the al-Nashri trial, the only ongoing sort of proceedings before the military commissions at Guantanamo today in 2013. So back in 2008, he issued some rulings that were favorable to us, some rulings that were not favorable to us. I guess, part of the calculus on the government's side was that there was a new administration coming in. Moreover, they didn't particularly like some of Judge Pohl's rulings on suppression. And because it's the commissions, because under the commission rules, there is no speedy trial clock, because they can hit the reset button as many times as they want to, obviously they took advantage of that. And so they basically pulled the plug on their own case. They withdrew the charges. They had them dismissed, bringing Mr. al-Darbi back to where he was before he had been ever charged with anything. So in a normal judicial proceeding, that would be considered a huge success for the defense, right? You managed to get the charges against your client dropped. But in the military commissions, it's sort of meaningless. I mean, I'm not trying to minimize the reality that it was a relief to Mr. al-Darbi to no longer be in jeopardy in that way, in legal jeopardy in that way. But it was meaningless in the sense that they could renew the charges the very next day or 2 or 3 years later, which is what they did.
Right.
So the charges are withdrawn and dismissed by the prosecution in 2009. Obama administration comes in. They choose to hold on to, at that point, it became clear that they had chosen to hold on to the military commissions, which they should have scrapped for a bunch of reasons, including the ones I've mentioned and many others that we'll get to. And essentially, we were in a holding pattern in that case on the commission side until August of 2012, when new charges were sworn. And now those charges have still not been referred. So the military commission system, like the courts martial system, functions in a way where the military prosecutors swear out a set of charges. Those charges go to what's called a convening authority, and only when the convening authority signs off on the charges and refers them to a military commission does the case move forward. But again, because it's the commissions, in kangaroo-like fashion, for lack of a better term, that can take forever. And so for over a year at this point, the sworn charges, the new set of sworn charges from August 2012 against Ahmed al-Darbi remain pending before the convening authority, awaiting action. So when my client asks me whether or when this case is ever going to move forward, I simply can't answer that, because it's in the convening authority's hands, and there's no structural pressure on him to take action. He can sit on it forever. He could move on it tomorrow. What's one thing that was interesting to note, and this also illustrates sort of how the military commission system by design, it was set up to favor the prosecution, even more so. Yeah, even more so than any other. I mean, I'm very critical of the way that the Article 3, like the federal courts function, and even the way state courts function in criminal cases. But even if you look at just how federal courts function in so-called terrorism trials, it's hugely problematic, and we could have a completely separate conversation about that. But the military commissions stack the odds in the prosecution's favor even higher. I mean, it's a system that was designed to produce convictions over justice. It is designed to offer prosecutors all sorts of shortcuts. It is designed to protect the secrecy that the government wants to protect. So secret evidence can be used, coerced evidence can be used, the accused can be excluded from their own proceedings in many ways. Sometimes, I think the prosecutors might argue sometimes that they can proceed ex parte, excluding even defense lawyers. So it's really a system that offers the prosecutions all sorts of shortcuts. The most important, I think, function of the military commissions, and this is where the secrecy comes in, is to enable the government to proceed with these cases despite the elephant in the room, which is torture. Yeah. Because all of these cases have torture at their heart.
Mr. Al-Darbi included.
Mr. Al-Darbi being an example, obviously the 9/11-5 being another example, people like Khalid Sheikh Mohammed, al-Nashri as well. I mean, any case that you can think of that's being talked about in the context of military commissions today will by necessity feature torture prominently, and that kind of explains the design of the military commissions, because if there would be no need for their existence were it not for that imperative, getting around torture, being able to secure convictions despite the sort of the prominent role that torture played in a lot of the histories of these cases. So with Mr. Al-Darbi, the charges that were sworn out in August 2012 remain pending, and we're just basically in a holding pattern.
But the other thing you mentioned before, testimony gotten through coercion is allowed, but testimony gotten through torture is not allowed.
Yeah, I mean, but even that, right? I mean, it's like, so you
what
can,
does that mean?
You can look at it in three ways, right? I mean, there are three conceivable grades legally. You can think of torture as sort of the highest, most extreme form of sort of coercion. You can think sort of the next lowest thing would be cruel, inhuman, and degrading treatment, and then below that is coercion. Statements extracted through any of the three, coercion, CIDT, or torture, would be considered involuntary. Now, the commission rules as they exist today are clear that tortured evidence, perhaps even CIDT evidence, cruel, inhuman, and degrading treatment evidence, is not admissible. But who makes that determination? The military judge. So if a military judge presiding over a military commission at Guantanamo decides that, despite the defense's argument that particular forms of coercion constituted torture, if the military judge in his or her discretion deems that the abuse that took place does not rise legally to the level of torture, then he can simply make the decision about whether it's, if it's probative enough in his view, it can be admitted, it can be used. And so that's even where the military commissions pay lip service to the notion that tortured evidence cannot be introduced at trial against the defendant. The devil is always in the details with the military commissions, and when you look at the practice of it, it vests the military judge with a great deal of discretion. And that's complicated. I mean, I think what further highlights how troubling that is when you look at the military commission rules, there are provisions that insulate the military commissions both ways, in the sense that if a military judge in a military commission issues a ruling on a legal question, that opinion that was written by the military judge, if he wrote an opinion, cannot be used in the regular courts martial system. There's a provision in the rules that prevents sort of anyone from citing what a military judge in a military commission says as precedent in the regular military courts. Why is that? Because we want to insulate our own men and women in uniform from the bad law that the military commissions are going to create. And that goes both ways, right? Yeah. And so I can spend all day citing Supreme Court precedent from the highest military court, international law, to a military judge in my military commission case. But ultimately, it is entirely up to her or him to decide whether or not to follow that law. None of that law is binding on her or him. Now, probably in practice, because the judges are going to be lawyers, just by reflex, by professional reflex, they're going to tend towards deference to those authorities. But they know that they aren't bound by those authorities. And sometimes where it really matters, they will say, well, this is not a regular court. These are not regular cases. the authority you cite is instructive, but it isn't binding, and here are the reasons why I'm going to go a different way here.
Instructive. This, it seems like this Orwellian use of language almost, especially when you're talking about coercive techniques or interrogations or torture. It's what we say is okay, and you can just stick with that legal precedent. That's how you have to. That's how you're forced to go forward.
Yeah. And the use of language. I mean, you can look at it from the commissions on down to even the everyday conditions that our clients at Guantanamo, my clients at Guantanamo endure, and how they're described by the authorities. So if I go to the media and say, my client Shaker Aamer has been held in solitary for months, and then the media takes that, like a journalist takes that back to the Department of Defense at Guantanamo and says, Shaker Aamer's lawyer is saying that he's in solitary. What they'll say in response is, no, we don't have solitary confinement at Guantanamo. And the reason for that, again, is they've defined it so narrowly as to define it out of existence. So in their view, it cannot be solitary based on their definition, as long as a prisoner can hear another prisoner's voice. So even if Shaker Aamer, and this is true, I mean, this has happened with not just with Shaker, with many of my clients, but even if, taking Shaker as an example, Shaker spends 23 hours out of every day on lockdown by himself in his steel cell, 8 feet by 5. He is allowed out to a recreation cage from 2 to 4 a.m. by himself, has no social contact with anyone other than his guards. As long as Shaker Aamer can bend down in his cell, shout through the slot in his metal door through which they give him food to another prisoner who may be at the other end of the cell block in his cell, and as long as that prisoner can hear Shaker shouting and can respond, and Shaker might be able to hear him, in the military's view, for that reason, it is not solitary.
Even though he has no real, actual human contact with fellow inmates.
And by every recognized legal definition, including the one we use in domestic prison facilities, that is solitary. Most domestic prisons wouldn't even argue with that, federal or state-run. They would concede that yes, that's solitary confinement. It's even gotten so ridiculous that Shaker, that same client, once described to me that he would tell his captors that because he speaks fluent English, and so he would complain to them about being held in isolation, which is a synonym for solitary confinement.
Right.
And they would dispute that. And then he told me that he was being taken to a meeting with me, and on his way to the meeting, on his way out of his cell block, there was some kind of an LCD display, I guess, regulating, I don't know if it's like electric flow or the air conditioning flow into the cell block. There was an LCD display that basically read isolation block. And so he was laughing because he was saying, their own systems acknowledge that this is an isolation block, yet they refuse to acknowledge that in conversation with him.
Maybe we can get to a little bit more about Shaker Aamer a little later, but I wonder if we can go back to Ahmed al-Darbi for a little bit and talk about how he ended up in Guantanamo in the first place, and what his story was there.
Yeah, I mean, I think a lot of that is actually in his, or some of that is in his declaration, and it's probably best for me not to get into it too much.
Okay.
Is that fine?
Yeah, absolutely. So going back to,
but in terms of what we started with the commissions, do you feel like we've sort of covered that enough, or
we can keep going on the commissions if you want to.
It's up to you. I mean, if you have other questions about the commissions, or if you'd rather move on, I completely defer to you.
Well, you talked about how he is he's basically just languishing now. He's waiting for the convening authority to do something with the charges that are before him.
Yeah.
So he's basically in a state of legal limbo, and has been for a while.
Yeah.
Right. So what's next for him?
Yeah, I mean, I think that there really isn't much I can say, because this is exactly the question he'll ask, and it's really sort of out of our control. In a normal court system, we would have been able to say, look, there's a speedy trial clock that has run, and so now we can go to a court and ask for you to be released because they're not going to charge you. But that's simply not the way it works here, because the government can have it both ways. Again, going back to sort of that earliest moment, that earliest sort of bifurcation in the road when we went down the war sort of paradigm path, I think given that that's where we are now, the government can always fall back on continued indefinite imprisonment under their interpretation of the law of war, making the men at Guantanamo, in their view, in the government's view, detainable until the end of hostilities that have, that are very hard to define, right? Because they're not geographically or temporally limited. I'm sure there are some actors in government who would say, even after the end of hostilities in Afghanistan, the conflict still won't be over. And so it's really unclear, but again, within that war paradigm, the government has a host of options. And I think that's what's really dangerous, the ability of the government to toggle between these different modes of state violence. So the fact that the government has a range of options at its disposal, that are reflected in what we now know is the government calls the disposition matrix, right? That they can, for any particular individual that is of interest to the government, as long as certain parameters are met, right? That they be overseas, for example, there's a range of options. You can try that person, you can execute that person, you can, send them over to another country for questioning and detention. You can hold them indefinitely in a U.S. military facility. You can bring them to the United States and make them stand trial before a federal court. You can hold them in a military facility and try them by military commission, or not, or hold them indefinitely under the law of war as long as they qualify as an unprivileged enemy belligerent, which is sort of the successor term to enemy combatant. So the fact that the government has all of these options at its disposal is what's really troubling, and I think that's different from the way things stood, I think, before this historical moment, like this post 9/11 moment. Not that the government didn't engage in all kinds of dirty business back then, but I think the default, the norm back then was that publicly, whatever dirty work the government was engaged in wasn't acknowledged and claimed as a legitimate policy option the way it is today. Today, a lot of this stuff is on the table. A lot of stuff that previously may have been done covertly, whether we know about it or not, today is a sort of openly a part of the legitimate array of options at the government's disposal, or sort of that array of options that the government claims is legitimate.
And they keep changing the rules and extending the stays of imprisonment and
right.
So
we had said we'd talk about commissions, and then there were a couple other things on your list too, right?
Yeah, we could move on to talking a bit about the hunger strike of this past year.
Okay.
So your client, Mr. Zuhair, had been on his own hunger strike for a very long period of time before he was ultimately released. And your client currently, Mr. Faraj, participated in the one that I guess the numbers grew to about 100 or even possibly more. What was your reaction to this year's massive sort of hunger strike compared to the one that you saw your client, Mr. Zuhair, go through?
So Ahmed Zuhair, Saudi national, held at Guantanamo. He launched his own individual hunger strike in June of 2005. Wasn't, there was a group of people who were with him, but, most of them sort of came in and out of hunger striking over a period of years. But Mr. Zuhair and another Saudi national by the name of Shalabi, who began his hunger strike a couple of weeks after Ahmed did in June of 2005, They stayed. They were continuous hunger strikers. They never suspended their hunger strike. Mr. Shelby remains on hunger strike today. So when you think of it, this is a man who has been on uninterrupted hunger strike since June of 2005. He's the single longest running hunger striker at Guantanamo. I'm sure he's shattered all kinds of world records. And he's paid the price, I think, with his health, both physical and I'm sure to an extent, psychological and emotional. Mr. Zuhair, basically, he started his hunger strike in 2005. When I first met with him in 2006, when he retained me and my team of students to represent him, and at the time I was teaching at. I was about to start teaching at Yale Law School, and I was there from 2007 to 2009 and represented him with a team of students there out of Yale Law School. He, one of the first things he said to me was, here's how we're going to work. I requested you as my attorney. I'm going to come for all of our meetings. I'm going to be, frank and truthful with you. Whatever I can provide you with to, facilitate your work, I'll do that. But in exchange, I don't want you to ever try to talk me out of my hunger strike. And he made it very clear to me and to my students from the earliest point that this was the one way that he had left to exercise his human dignity and his autonomy and his agency. It was a peaceful form of protest and resistance to injustice that he really wanted to engage in, and he made it very clear to us that he would not end his hunger strike before being returned to his homeland of Saudi Arabia. And that's exactly what he did. He we represented him. We began representing him in 2006, 2007. Boumediene came down, so we pressed forward as aggressively as we could. We had a good judge on the case who sort of was equally mindful, like a fair judge, who was equally mindful of our client's own interests and how significant the deprivation of his liberty had been, alongside the equities on the government side, national security equities, whatnot. So we had a fair judge. We pressed forward aggressively. We, after Boumediene, we had the government produce their factual return, which is their evidentiary justification for Mr. Zuhair's imprisonment. Part of that was classified, part of it was unclassified. We responded we filed a traverse, which is a response to the government's accusations and whatever evidence they put forth. A third of what we said was public on the unclassified side, 2/3 were on the classified side. We're working with the government towards declassifying that. But just to summarize it without getting into anything sensitive, the accusations were very, very poorly and thinly substantiated. We were literally able to rip apart the evidence that the government presented. And once we saw that, we started pressing for a trial, because we had responded in writing with our own evidence and with our own rebuttals of the government's evidence, and we really wanted to go to trial to get our judge to look at everything we had put forth and make a decision whether or not Mr. Zuhair's imprisonment for all of these years had been justified, legal. The government resisted that to an extent. They didn't want the judge to set a trial date, but ultimately the judge did. He set a trial date towards the end of June 2009, if I remember correctly. On June 12th, 2009, exactly the first anniversary of the Boumediene Supreme Court decision holding that the prisoners at Guantanamo had a right to habeas corpus review, my students and I got a communication from the U.S. Department of Justice informing us that Mr. Zuhair had been placed on a plane to be returned to Saudi Arabia. And that was their way, I think, of avoiding the embarrassment of going to trial and losing, because I think, with the evidence we had put forth, the way we had responded to their evidence, and the fact that we had a judge who was not afraid of contradicting the government on matters of so-called national security, they kind of saw the writing on the wall and decided that the path of least resistance would be to send him back to Saudi Arabia. So he actually kept his promise. I mean, he remained on hunger strike all the way until his foot hit Saudi soil. and only then did he interrupt his hunger strike when he saw his mother. He was placed in the Saudi rehabilitation reintegration program. Now that's a form of detention in my view. I mean, obviously it isn't Guantanamo, and obviously it isn't like sort of your average Saudi prison either, in the sense that it's better, but it's still a deprivation of liberty. So for 3 years past that point, he remained in the Saudi rehabilitation reintegration program until the spring of 2012, when he was finally released for good. And so now, he's home with his family in Mecca, Saudi Arabia. He recently agreed to give the Associated Press an interview about his experiences, commenting on, I think the journalists from the Associated Press's interest was really to get some insight into the mentality of a hunger striker, the motivations of a hunger striker, what it's like to be in that position at Guantanamo. And so Ahmed obviously is uniquely positioned to shed light on that, and he's the next best thing to being able to interview an actual hunger striker at Guantanamo. And so he agreed to do that interview, and he explained to the journalist that it was sort of the one way of protesting peacefully, like the injustice of Guantanamo, and that many times that often his own family didn't understand and couldn't understand, that the prisoners' families just couldn't understand what it's like to be there, and why their loved ones feel compelled to engage in something as extreme as hunger striking, extreme in the sense that it really exacts a cost physically and psychologically, and sometimes it's a long-term cost. I mean, part of what Mr. Zuhair explained to the Associated Press journalists is that even today in 2013, years after he finally suspended his hunger strike, he still suffers from some of the physical health consequences of having been on hunger strike for such a long period of time. That his back just hasn't been the same, that his joints just don't feel the same. He used to be extremely athletic. He just isn't able to do any of that anymore, and he's still a relatively young man. So I think, but for him, I think it was the way he chose to, remain human at Guantanamo. And as paradoxical as it might sound, I think for him it was the way, perhaps the only way to survive Guantanamo. To sort of put himself at great risk, not just because of the effects of hunger striking on his own system, physically and mentally, but also because of the authorities' response to hunger striking and their constant attempts at breaking his will. And we saw a lot of that play out with the recent hunger strike at Guantanamo. So, as you mentioned, my client Abdul Hadi Faraj, who's a Syrian national, my other client Muad al-Alwi, who's a Yemeni national, both of them, actually all of my clients went on hunger strike. Shaker Aamer was also on hunger strike. Muhammad al-Qahtani in Saudi was on hunger strike for a short period of time. Ahmed al-Darbi was also on hunger strike. But, and as you mentioned, at its height, that hunger strike included the majority of the prisoners at Guantanamo. Depending on whose count you believe, the prisoners will say up to 140. The prison authorities were saying, different figures between 100 and 120 out of the 166 prisoners that were there at the time. But essentially, the majority of the prison population at Guantanamo had launched a concerted collective hunger strike. And the spark for it obviously was a particular incident where prisoners believed that prison authorities had searched the Qurans in a way that they hadn't before. So I think that was the spark. But the real underlying motivation that fueled the hunger strike, as expressed by my clients and other prisoners, was just the single, constant, unchanging characteristic of Guantanamo that has remained the same, whether you look at Guantanamo in 2002 or you look at it in 2013, regardless of changes in conditions, which is the reality of indefinite imprisonment without charge, without knowing whether or not you will ever get to be reunited with your family, with your society, with your loved ones. And many legal and medical experts will tell you that something as extreme as that, indefinite imprisonment without sort of knowing, without any kind of certainty about if you'll ever get out, that can amount to psychological torture. So even if you set aside all of the horrible things that we've we know some of the men at Guantanamo have survived. We know from government documents now. We know from survivor accounts. We know from their own stories. Even if you set all of that aside, just that one constant, unchanging fact that they're being held, they don't know if they're ever going to get out. That's really hard to negotiate. And I would say not just for the prisoners themselves, but also for their spouses, for their loved ones, for their families. So it has the effect sort of ripples out and touches not only the prisoners and their immediate families, but also their societies and their communities as a whole. Particularly, if you sort of take into account the way societies like Yemen are structured and the importance of expanded families and clan and tribal relations. So so really like that rippling out of individuals who are affected by this injustice that's being visited on the men at Guantanamo really brings in many, many more people than most, I think, Americans realize. So, with this hunger strike, what was notable to me was that they were able to, there was sort of a unity in motivation and in action, that prisoners who have very different outlooks, who have very different political perspectives, who have very different individual goals and desires, were able to find unity in action and motivation to that extent, that the overwhelming majority of the prisoners would engage in sort of a single act of political protest, and it was successful. I mean, in the sense that politically, they were able to leverage that action and transform it into political pressure that brought President Obama from a place where he was not willing to even talk about Guantanamo to a place where he was forced to address it twice in 2 public addresses, to a place where he was forced to revoke the moratorium on repatriations to Yemen and Saudi Arabia, to a place where he reopened the office of Guantanamo closure and appointed an envoy. Now, I don't want to overstate the importance of all of that, because we had an envoy for the closure of Guantanamo for years, from 2009, for the entire first term of the Obama presidency until Obama shut down that office, and little was done. So ultimately, what it boils down to is political will, President Obama's willingness to make good on that promise and to really pay the political price and expend the political capital to make good on the promise of closing that particular facility. And that political will on the Obama administration's part has been lacking for the better part of that first presidential term. We hope that what's happening now is a change, and that the 2 Algerians who were recently released in 2013 and sent back home will be the first of many. It makes sense to start with the prisoners, the majority of prisoners at Guantanamo who've already been approved for release. But I don't really buy into that distinction too much. I think essentially all of the prisoners at Guantanamo should be either released or charged ultimately, and that there is no place for indefinite law of war detention in this kind of context. So to my mind, if the administration wants to start with those who've been cleared for release, if that makes sense for bureaucratic reasons, so be it. But all of the prisoners must be repatriated or released, or charged and tried if there's a basis for it. But I think the hunger strike was successful politically, bringing all of these different kinds of pressure to bear on the American political administration, be it international pressures from allies, from international organizations, from human rights groups who were denouncing the hunger strike, denouncing indefinite imprisonment. It renewed international media attention on Guantanamo and on the injustice of indefinite imprisonment. I mean, so much so that segments of the American public were taking notice. Rolling hunger strikes were organized nationwide, solidarity hunger strikes among Americans. And these expressions of solidarity, I think, were among the most meaningful for my clients at Guantanamo, at least. When I would describe to them the actions by organizations like Witness Against Torture, the rolling solidarity hunger strikes, the fact that people were staging protests outside of the White House, and people on hunger strike, Americans. I think that really resonated with them. I mean, they're very grateful and they're very thankful for any gesture of solidarity, but they were always very, across clients, they were always very intentional about asking me to, convey their thanks and their appreciation to those members of the American public who stood by their side in their time of need. And I think sort of the building of those kinds of bridges and alliances is really transformative. I mean, it's transformative for the people here in the U.S. who take those actions, and it's transformative for my clients who, brings them to a different understanding of the complexity of American society. And so I do think that act of collective protest was tremendously successful. It's not unusual. I mean, there are studies that will tell you that prison hunger strikes are successful to the order of 70%. So the odds, once a prisoner is willing to sort of pay that price and take the extraordinary step of endangering their own life and going on hunger strike, they will be able to achieve some political advancement, perhaps not all of their goals, but at least some of them. And I think for most of the prisoners at Guantanamo today who are on hunger strike, they're not waiting to see. Like many of them have chosen to give the Obama administration a reprieve. They've suspended their hunger strike temporarily now that the Algerians have been released, to see if more releases will follow. If they come to a point where they realize that the release of the Algerians was just sort of a blip, an aberration, and really the policy hasn't changed, the political will is still as it was before, the inertia is still the same, then I think they'll go back to their hunger strike. If on the other hand they see sort of a favorable evolution over time with more prisoners released, then I think they'll go on eating. Now there is, however, I think at this point 30 to 40 prisoners who are still being force-fed, tube-fed, including my clients, Muaz al-Alwi and Abdul Hadi Faraj, at least on my information from my last contact with them. So they're maintaining their hunger strike because they're somewhat more skeptical. But I think many other prisoners have decided to sort of suspend it, at least temporarily, to see what the administration does.
Yeah, just see how it goes. The hunger strike really brought the human cost of Guantanamo back into the public eye.
Yeah.
And that is something that is so often glossed over with all this talk about politics and what the Obama administration should be doing versus what it actually is doing. Can you talk a little bit about the human cost as you saw it and your experience with your clients?
Yeah, I mean, look, it's primarily, I think for many pundits and many lawyers and many people who track this stuff here in the United States, it's almost like a soap opera having to do with judicial opinions and what have the courts said here and what are the policymakers saying there. To me that's part of the problem, in the sense that, in a way, unwittingly, it participates in a process of dehumanization because it takes the humanity of the population that is most directly affected out of the picture altogether and kind of like elevates the sort of this human situation into really just a policy and legal debate. So for me, primarily, it's about the people involved. And for my students, the same is true. I think that's really the main motivation for my students who are working on these cases. And the people involved include our clients, obviously, who are sort of most immediately in the crosshairs, but also their families, their communities, their societies. And we try to work with all of those circles. There's no, for Shaker Aamer, he hasn't, he never met his son, for example. He has a son who was born on February 14th, 2002, which is when Shaker Aamer arrived at Guantanamo, having been held at Kandahar before in U.S. custody. Ahmed al-Darbi, same thing. He's got a son, whom his wife was pregnant with that child when he was taken into U.S. custody. He's never met that child. He's also lost his father while he was in prison. Ahmed Zuhair lost a parent when he was in prison. Muaz al-Alwi, has lost relatives. Abdul Hadi Faraj doesn't even know if his family is still alive in Syria because of what's going on there. These are real, lasting human costs. They're tragedies, really, and sometimes it's a surprise to me that my clients have been able to survive to the extent that they have, not just physically but also like psychologically and emotionally, despite sort of the difficulty of all of that. It's kind of unfathomable, really, that they can keep it together despite all of that. When I think about my client Amin al-Bakri, who was kidnapped off the streets of Thailand, probably by the CIA in 2002, has been in U.S. custody since then, now at Bagram. The same thing. He hasn't seen his children. His father, who's been advocating relentlessly on his behalf, finds it really hard to process hard news. I mean, he's told me, if you have bad news, don't call me, call my son, Amin's brother. So whenever there's bad news or negative developments in the case or in the advocacy efforts that we're undertaking on behalf of Amin or other Bagram prisoners, I'll call Amin's brother. If there's good news, I'll call his dad. I mean, his dad is an older man. He's, he just can't bear it. And I think that's true for many people. Like Shaker Aamer, my Algerian client, when I picked up the phone with my students to call his wife to let her know that he was on a plane to Algeria, she broke down and there was silence, and then she broke down in tears and cried. And that was the first time I had heard her cry. And we had been working with her for years. I mean, we'd been getting documents from her. She had been sort of a very steadfast advocate on her husband's behalf, and she was a huge support to our efforts legally. It occurred to me then and there that despite all of our work with her all of those years leading up to his release, she had never once allowed herself to cry. And it was only once we told her that he was finally on a plane headed home that she was able to let her guard down, I guess. And so that really triggered something for me. I realized it sort of at an abstract level, but it really made it very concrete for me when that happened on the phone and she started crying. Just how difficult and impossible this is, not just for the prisoners themselves, but for their families in larger circles. Obviously we can talk about the policy ramifications as well. The fact that the Obama administration, even if it gets to a point where it closes the prison at Guantanamo, that at that point in time the closure of that particular facility is going to be largely symbolic, because the policy of indefinite military imprisonment without charge, that policy option, will have been fully preserved by the Obama administration. And what better illustration of that, what better proof of what I just said than the existence of the prison of Bagram, where Amin al-Bakri is being held, right? Because over there, the Obama administration actually, and we're going to court we're going before the Court of Appeals on Tuesday for the second time on the jurisdictional question of Bagram. So the Obama administration continues to argue along the exact same lines that the Bush administration argued with respect to Guantanamo back in 2003 and 2004 before Rasul, which is to say that with respect to Bagram, the Obama administration continues to say today in 2013, and they will say this in court before the D.C. Circuit Court of Appeals on Tuesday, that the jurisdiction of U.S. federal courts does not extend to what the U.S. government does to men imprisoned at Bagram in Afghanistan, because it's a theater of war, and irrespective of the fact that those men were brought into that theater of war, men like Amin al-Bakri were brought into that theater of war by the United States. So they will continue to make that argument. It's very similar to the argument that the Bush administration made as to Guantanamo, saying, hey, no jurisdiction at Guantanamo. So when you think about that, I think it really highlights the fact that the Obama administration wants to preserve that option, wants to preserve the option of being able to hold people indefinitely without charge, even if it brought those people into a theater of hostilities. And that's a really radical notion, that a government can kidnap someone who is not a citizen of a country at war with the United States, can kidnap them off the streets of another country that is not at war with the United States, that is far from any recognizable battlefield, that they can take them into a battlefield, into a detention facility that is within a battlefield, like Afghanistan, a zone of hostilities, which in and of itself is a violation of all kinds of international law, right? The fact of abduction, rendition, let alone rendition into a zone of hostilities, which is dangerous, right? Afghanistan, 2002, 2003. That the U.S. government can kidnap that sort of person from a place like Thailand, bring them into a theater of hostilities like Afghanistan, and then go into federal court and say, Judge, you have no authority to review the legality of this person's detention because they are in a zone of hostilities, even though we brought them there by our own discretion. That's a clear roadmap that allows this administration, any future U.S. administration, to circumvent any meaningful judicial review over the imprisonment of people overseas. And that's the policy option. That's the option. That's the tool that the Obama administration is fighting so hard in federal court to preserve. We are just trying to get into the door. We're trying to get, Mr. al-Bakri his day in court, essentially. We just want to be able to go before an impartial judge and say, Judge, here are the government's accusations. Here's what they claim is the evidence that justifies his imprisonment for well over a decade at this point, without charge. Here's our answer. You decide whether or not this man's imprisonment is legal. That's all we want to do. But we're still at the threshold. We're still trying to get through the door, and the Obama administration is taking a position that is virtually indistinguishable from the position that the Bush administration took over a decade ago with respect to Guantanamo. And so I think that's just one illustration of kind of the longitudinal and impact of the Obama administration's normalization of many Bush-era policies. Because now that the Obama administration has fought so hard to preserve this kind of option, indefinite imprisonment at a place like Bagram for non-citizens, I think it's a challenge that will be with us for a generation or more, along with a bunch of other policies.
It's a very dangerous precedent to set.
Yeah, absolutely.
And Bagram so rarely gets mentioned when we're talking about Guantanamo, but in fact it's a much larger, much worse facility. One of the things I saw this week was, and this goes back to our conversation about the human cost and humanizing the individuals detained at Guantanamo. There was this piece in the Miami Herald of it was a feature of photographs of the detainees.
Yeah, I saw it.
Yeah, and that's such a rarity. In terms of battlefield photography, any photography that comes out of Guantanamo, just pictures of the detainees besides what look like just mug shots. It seems like that in and of itself is an effort to keep this issue as out of the hearts and minds of the American people as possible, to completely dehumanize them. And as you say, your client Shaker Aamer hasn't seen his own child. Shaker Aamer is one detainee who, it seems there are much more campaigns to get his release than most of the others. Can you talk a little bit about what his status is and some of those campaigns, I guess especially in the UK, that have occurred to try to get his release?
Yeah, I think Shaker doesn't view himself as in any way like different or from other prisoners at Guantanamo, and I think he views his own individual struggle as a part of that collective struggle, and he's said many times that really his objective isn't his objective isn't so much his own release as it is like the shuttering of that prison as a whole, and that if by accepting release himself he can be in a position to accelerate the shuttering of the prison. For example, if he's returned to his family in the United Kingdom and he's able to speak out, and if that accelerates the process of closing the prison, then so be it. But he's always linked his own individual struggle, his own personal struggle, to the larger political one, the larger sort of group struggle that involves all the prisoners at Guantanamo. I think Shaker's been, he doesn't view himself as different or exceptional, but I think the outside world, you've kind of you've touched on this, that there are these campaigns that have to do with Shaker's release, and you don't see similar campaigns for others. And I think part of it is because he's a former UK resident, He has family in the United Kingdom. They're all UK subjects. That they speak English. That they come from an English-speaking market. That their advocates are English. I mean, I think there's sort of a collection of factors that kind of make his case more palatable to English-speaking audiences in the UK or the United States. Substantively, it really isn't different. I mean, it's indefinite imprisonment. There are many other prisoners like him at Guantanamo, including ones who have been approved for release by the Obama and the Bush administrations, right? So he doesn't view himself as different. The Western public, or some segments of the Western public, might, for reasons having to do with his, I guess, immigration status, that he was a former UK resident, that his spouse and kids are all UK nationals. I think the prison administration may view him as different. But again, that is not for reasons having to do with what he did before Guantanamo, or what he's alleged to have done before Guantanamo. However, it is entirely for reasons having to do with what he's seen as having engaged in since his arrival at Guantanamo. Some of which he proudly owns, like the fact that he has no interest in being seen as a compliant prisoner, that he very much views peaceful resistance to injustice, like civil disobedience, as his main currency in a place like Guantanamo, as the only way he can retain his humanity and survive as a person. And so he does that every step of the way. He isn't particularly interested in improving his conditions at Guantanamo, earning the privileges that the prison administration can bestow on prisoners or revoke at will. He sees it very differently. He thinks his approach to it, his philosophy, is to I guess use civil disobedience strategies every step of the way to signal to his captors that this isn't okay, that he's still a human being, that this is still an injustice. He wants to be that constant reminder to the guards, because he recognizes the guards' humanity as well, and he feels sorry for many of them, because many of them are 18, 19-year-olds who have been sort of trained out of their better instincts. They may have instinctively felt like treating him humanely, but they're being told that he's this beast, this animal, and so they're being trained to treat him and the other prisoners in a dehumanizing fashion. So he wants to use civil disobedience, in addition to his ability to speak English directly to the guards, as a way to help them retain their humanity as well. So I think that's very much his approach, and it's because he's taken that approach, it's because he can't be bought off, essentially, that I think the prison administration at Guantanamo views him, and has viewed him pretty consistently for years, as a threat, and which is why he spent a significant portion of those years in solitary confinement, because they don't want him to be talking to other prisoners, serving as an example, influencing other prisoners. But in the end, even in that attitude, he isn't unique, because to me, one of the most inspiring things about this hunger strike that started at Guantanamo and that grew to encompass the majority of the prison population this recent year is that it started in Camp 6. Camp 6 is, at the time at least, Camp 6 was sort of the model state-of-the-art facility that the prison administration at Guantanamo was showing off to visiting delegations of journalists, reporters, foreign and U.S. dignitaries alike. They would take them on tours of vacant cell blocks on Camp 6. They would show it off. They would say, hey, this looks like any other federal detention facility in the United States, and here are all the wonderful things that the prisoners have access to, and they can watch television, they can listen to the radio, they can even play video games, they get ice cream, they get food. So that's Camp 6. And so the fact that the hunger strike began there, of all places, to me is what's particularly inspiring, because it was in this way that the prisoners were sending a message to the prison administration, to the U.S. government, and to the world, that it really doesn't matter what amenities you may throw in there. Ultimately, this is a place where an extreme form of violence is visited on people who have not been charged. And that's the violence of indefinite imprisonment without charge. And regardless of what you do to the surrounding conditions, it's still going to be lived and experienced as an injustice, and it's still something that the prisoners will want to resist through an act of civil disobedience, like a mass hunger strike. And it's simply as unacceptable in 2013 as it was 10 years prior, 11 years prior in 2002 when the prison started, regardless of the superficial differences between the way Camp X-Ray looked and the way Camp 6 looked 11 years later. Fundamentally, it was still the same place, and fundamentally, it was still about indefinite imprisonment without charge. And for those reasons, they wanted to sort of, cry out for justice. And they did it in a very powerful and compelling way. And it wasn't that they were suicidal. I mean, a lot of my clients said, hunger striking isn't easy. We're doing it because, we understand we're going to pay a price. We understand it's going to cost us physically and psychologically and emotionally, and that the administration is going to crack down on us and try to break our hunger strike in many different ways, as they have. We understand all of that, but it's important to send the message all the same. And we're not doing it because we're suicidal or we want to die. We're doing it precisely because we aren't suicidal and we want to live and we want to be released and return to our normal lives with our families or start families. And many, down to the details, I mean, many of my clients would say, my gesture of protest, my gesture of civil disobedience is not to accept food from my captors, because it's one of the few things I can choose. It doesn't mean that I would reject tube feeding. I just reject force feeding, or I reject tube feeding that's being implemented in an unnecessarily brutal way. And that was the same attitude as Mr. Zuhair's, that he would voluntarily present for tube feeding. He just didn't want to eat food voluntarily given from his captors. That was his form of protest. But he would voluntarily present for tube feeding. When the prison administration realized that he was going to keep this up indefinitely, they chose to escalate. They chose to ramp it up and to make the tube feeding more painful, more violent, more brutal, so that they could pressure him and hope that they could get him to a point where he would abandon his hunger strike, which never worked. But they did the same thing with these prisoners who went on hunger strike more recently. They started tube feeding them, force feeding them in the restraint chair, doing it in ways that were humiliating and painful and uncomfortable. Again, in a bid to break the hunger strike. It's not that it was necessary. It's not that all those prisoners presented a risk to themselves or to others, but it was just because the administration made a decision that it needed to put an end to this massive hunger strike, and that was one way that they thought they could do it.
Right.
Yeah. Are we out of time?
Well, we're just coming up past an hour here. Okay. You talked a little bit about about Camp 6 and how it now just looks like any other federal prison. Guantanamo now has this sort of permanent status. It's not just fences and barbed wire anymore. Now it's concrete. It's there. It's in the ground. Just to sort of close up here, are we looking at another 10 years of Guantanamo?
Yeah, I mean, I certainly hope not. And it isn't, I say that not because I think Guantanamo is so uniquely horrible, right? I mean, that's not why I'm saying that. Like I said, I mean, I think even if the facility were to shut down tomorrow, the Guantanamo idea will survive in many ways. And it survives at Bagram, it survives in the minds of policymakers, it survives in the law books. Policymakers know that they have that option. They will inevitably choose to exercise it again in the future, as all power is, right? That's the sort of irresistible temptation of power. It's in the law books as sort of a protected sphere of executive authority that you can detain people like that. Bagram is the illustration of that. You don't have to give them process. You don't have to give them habeas. Even when you do give them habeas, it is virtually meaningless. The D.C. Circuit Court of Appeals has made sure of that in the Guantanamo setting, that when we started post-Boumediene, we were winning 75% of these cases at trial, despite some pretty steeply stacked structural odds against us. The presumption, sort of the burden of proof being a preponderance of the evidence. That was all the government had to show, and even then they were losing those cases, but the Court of Appeal stepped in and made it even harder for a prisoner to win, virtually impossible. So despite all of that, I mean, I think, I don't think Guantanamo is unique, and I think there are many equally, if not more, horrible things going on in our federal prison system. When you look at the conditions that exist in places like Florence, Colorado, when you look at the ways in which certain terrorism trials are conducted in Article 3 courts, sort of bordering on punishing thought crimes. I really don't want to exceptionalize Guantanamo, but at the same time, we should recognize, some of its unique characteristics. And so, for my clients at Guantanamo, if the facility were to shut down tomorrow, that would be huge, right? For them personally, for their families, for their communities, there's no questioning that it would mean the world to them. But how meaningful would it be beyond that? I'm not so sure. Like I think at this point the damage is done. The Guantanamo idea is bound to remain with us for some time to come, a generation, if not more, I would say. And so the question whether this particular facility at Guantanamo Bay, Cuba, is going to close today, in a year, in 2 years, in 5, and 10, in that perspective becomes somewhat inconsequential. And that's for someone who's worked so long on these cases and on these issues, it's kind of an odd thing to say.
Okay.
Yeah.
Thanks.
Thank you.